So, everybody, welcome back to Vital Conversations with Nurse Eunice, where we talk about more than just health. We talk about life, legacy, and impact. Today's episode is incredibly important because legacy is so much more than just money. It's about protecting your family, preserving your values, and being intentional about the wealth, both financial and personal, that you leave behind. I'm so honored to welcome back two incredible attorneys from the HeiressLaw firm, attorney Karen Stiers and attorney Ruby Montes. In this episode, Legacy Beyond Assets, we're breaking down what families really need to know about protecting what matters most now and for generations to come. Let's get into it. Welcome, attorneys.
Hi, hi everyone. Thank you, Nurse Eunice.
It's so wonderful to have you back again. And for those viewers who may be catching us in episode 2, can you please introduce yourself? And after your introduction, tell us about episode 1.
Absolutely. So I'm Karen Stiers. I'm an attorney here in Florida, an educator and an advocate for families who want more to protect generational wealth and beyond. So my partner Ruby is going to introduce herself. Hi, Eunice. I'm Ruby Montes. I am the managing partner at HeiressLaw, and Karen and I have sort of are trying to create a movement where people who have usually not just been taught about estate planning and things of this nature, where we are now sort of just moving into a different mindset and
Yes.
discussing this and making this sort of like a normal conversation. And for the past 2 years, we've been sort of educating, not 2 years, a past year or so. We have been making it our mission to just educate people across the Tampa Bay area and just Florida and New York in general. So we're so happy to be here again. Yeah,
Well,
and on
thank
episode
you.
one,
Oh,
sorry, and on episode one, we
sorry.
talked about a little bit about what estate planning is, the difference between a trust and a will, advanced healthcare directives, and just documents that everyone over 18 should have. And so
Yes,
we're
yes.
happy to be back and talk about generational wealth and values and passing on other things.
Yes. And so vital conversations, these are conversations that are so important, and it doesn't have to be creepy. These are conversations that
No.
you can have with your family members, with your kids, because they need to know what your wishes are. They need to know what the important documents are, where the passwords are. And so
Mhm.
when I tell you that you're in for a treat, stay into the end. Also look at the link in the description area so that you can find out information about the Aries Law firm and how you can schedule your free consultation. So, ladies, what is today's episode about? What are we diving into?
Good. Okay. I think what's really important and something that we need to take into consideration when we think about estate planning is our cultural beliefs and our values, our traditions, things that again, we spoke last time at the first episode, things that LegalZoom are not going to prompt you.
Mhm.
So when we think about planning, we think about it beyond just money. It's not just about planning for what happens to the building you guys own or what happens to the business. We also want to make sure that, not that we necessarily control from the grave, but we have the ability to leave an imprint.
I love that.
Leave an imprint. And so when we structure trust plans for clients, and I do urge everyone to sort of review episode 1 because it gives you
Yes.
sort of the baseline knowledge of what we're speaking about. But we can tailor your family's trust to incorporate whatever those values may be. So, for example, we have clients who have a high importance on higher education, which most of us do as parents. We want our children to go to college and sort of acquire certain degrees and educational background, but it's not for everyone. But some parents want that. They want to say, I want them to at least get an associate's degree, a bachelor's degree. Some clients just say, I just want my child to either go into trade school, military school. So we can provide incentives for your children to reach those milestones.
That's wonderful.
So that's sort of something that is pretty neat that you want to think about again, it's not all about the money, how it's going to be invested. We want to keep on. So with that mindset, when you appoint your trustee, when you appoint your guardian, which we really didn't speak too much about, but the guardian is going to be that person who's essentially going to be like mom and dad if God forbid something happens to you.
Mm.
This is where it gets serious. You want to appoint, and a lot of people think to appoint the next logical person, which, in their mind may be their mother or their sister or their brother, someone along those lines. And while those may be great candidates, I want you to also take into consideration not just the family ties, but who shares in your same religious beliefs, who shares the same, if you are a Scientologist, for example, and your family are Christian or Catholic, or they don't believe Church of Scientology, you want to take that into consideration if that is how you want your children to be raised. So we have a lot of clients from different cultural backgrounds. I mentioned Scientologists, Jehovah's Witnesses. For clients who follow certain religions or certain customs, we want to make sure to incorporate those into, it's not, again, it's not a one size fits all. So we want to make sure to incorporate those things, and we have specific provisions for specific religions that we can put into our trust and estate planning documents to make sure that your beliefs are still passed on for one generation. And so you encourage it. Can't force it. We can't force your child to be a Christian. We can't force your child to follow the Church of Scientology, but at least we can encourage it.
Right. And they keep sharing those values and just sharing those values. And, I always tell people I'm an Afro-Latina from the Bronx, right? And so what does that mean? That means that, they're culturally very different backgrounds. And so when we take those things into consideration when we talk to our clients, because like Ruby said, we have clients from different faiths, different religious institutions. And, another thing that we do is we draft legacy letters, right? A legacy letter to your child, to your mate, to your children, whoever it is that you want to say something to when you're no longer here, right? We talk about passing down recipes. Who's going to make the macaroni and cheese when I'm gone, right? Wow. That's a secret recipe. And
it's so good.
Right. And so that's important. So to make sure that we not only just talk about legal documents, right? We like to talk about this as love letters, legacy love letters to those loved ones that you leave behind, who at the time are going to be, traumatized, dealing with death. And if you don't have your documents in order, right, those documents that we talked about in episode 1, and we hope that you go and watch it, because it'll talk to you and it'll tell you, what specifically it is that you need and want. And it's just directions and instructions from the grave. So people don't get left guessing.
And you hear that a lot, oh, I miss grandmother's cooking. I miss the recipe. And so here it is. We're thinking about wills, estates, power of attorney. We didn't think about those love letters. That is.
And I know it sounds kind of like, Hollywoodish. Funny because a lot of people always assume there's going to be a reading of the will because of, the movies we see. And that doesn't happen. But think of these legacy love letters as your final thoughts and wishes for whoever is. So we suggest doing one for your guardian. So the person who's going to continue to raise your children until at least the age of 18. So you want to, encourage them. If you go to church every week, every Sunday, you want to probably appoint someone who goes to church every Sunday. If you do encourage your children, you pay a high importance on higher education and going to college, then you want someone who has that same sort of philosophy that you do, who's going to share the same traditions. We celebrate Christmas Eve because we're Latinas. I want my children to celebrate Christmas Eve and continue that. So of course, I'm going to appoint someone who's going to continue those sort of same traditions, and then do one for each one of your children. As moms, we break down and it's just like, and we're going to be an emotional mess writing, but only write it one time. You don't have to write it and torture yourself every year. Obviously as your child progresses from one age group to another, you'll update it. But to your executor and your trustee, This is what I hope, I would like my real estate investments to keep going. This is how to monetize and continue to monetize my YouTube channel. This is, I like, and don't ever sell that Bitcoin. I like us, so these are all instructions that you should be leaving to each individual for each role.
Yeah, my takeaway from this first portion is that when if something were to happen to me, my son would more than likely move out of state. So, we still would have a family home that's in a trust, but I need for him to return to Florida to visit the grandparents that are in Florida.
Mhm.
And so whoever the guardian would be would have to honor those wishes because he still has family here. And so thank you for just pointing that out because
Yeah.
in my mind, yeah, that's what's going to happen. But if I don't document it, it's probably not going to.
Yep. Yep.
Exactly.
All right. And so, involving the younger generation, how do I not have a creepy conversation with a 13-year-old?
That's my favorite part.
Yeah, that's her specialty.
So, I'm a bit, and unfortunately, and I'm not sort of trying to insult my mother in any way, shape, or form, or my family or the way I was raised, but similar to a lot of people, especially in the Latino culture, we were never taught financial education. Money was just not something that was brought up. I knew that my grandfather made a couple of $100. He gave it to my grandmother. My grandmother paid the bills. But this idea of credit was not non-existent.
True.
So I have spoken or have tried to make sort of learning experiences with my children along the way so that they understand. So if you are into real estate, I do encourage you to speak to your kids about real estate, how it works. Bring them into those conversations. Now, it's funny. Did you remember were you there when we had the conversation with my son Ethan? And he said, well, I have it all planned out. If you and Khaleesi were to die, and he had planned out, he knew exactly how much money I had in life insurance. And he said, okay, I'll use this portion to pay the mortgage off.
Wonderful. Wonderful. Wow.
I'll use his money to pay off the mortgage. I'll live there rent free, and then I'll buy the car in cash, and that be a car. Of course, it's like some expensive Cadillac, and blah blah. And I'm like, you think you have it all figured out, and and that's great that he is even thinking on that level. I don't know, he's thinking about me dying, but
But at least he has a plan. He's been hanging around you. He's been listening.
he's been listening. He's been listening. But the whole point is that I wouldn't want you to pay off the mortgage. That's not good financial advice. And so, because there's good debt and bad debt, but he wouldn't know that because he's 19. He thinks it's the smart thing to do. Instead, I would say, hey, this is a really low mortgage, invest that money. But that's only the trustee. That's why it's so important to appoint that person. It doesn't have to be an attorney. Doesn't have to be a sibling or a family member. It must be someone that you trust and is going to be able to not necessarily know how the stock market works, but be able to sit down with a financial advisor and understand the financial concepts that are being explained to them.
Love it. Love it.
And mine is a little different because I think I parent a little bit different than Ruby, right? So my conversation with my kids is like, look, I'm not going to always be here, right? And my entire family passed away without an estate plan, right? I'm the first person that has an estate plan, and I don't want you to go through what I'm going through. And so, even at a young age, I've always talked to young children about the realities of life. Mm-hmm. So even if your children can get on an iPad and understand things that are happening electronically and digitally, mm-hmm. they know how to have, child appropriate age conversation.
Yeah.
And I believe in sweat equity. So even with property maintenance, so he's helping me pressure wash. He does yard work. We talk about taxes. But I haven't had that conversation. I have a insurance policy just strictly to pay off the mortgage. Mm-hmm. And so after listening to what you just said, I may have to reconsider that. But So, but having that conversation with him, I think I'm going to be able to do so now. And
Oh,
especially once we have the actual trust
yeah.
executed, we're going to read through it together.
Yeah.
And I think that's important. And I also didn't really understand the difference between a trustee and a guardian
Right.
because I was thinking that the trustee would also be the guardian. So thank you for explaining that too.
Yeah. So you can name different people. Some people name the same. I did more of, like I said in episode one, a sort of a checks and balances. So I have an 11-year-old daughter. I named my sister because we're sort of raising the kids the same way. We have the same tradition, same culture. So it makes sense. Pointing a sibling a lot of times makes sense, but you know your family better than I do. That's why you have to sort of confide in your attorney. Let us know, hey, my sister's great on paper, but blah, 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 blah,
Mm.
blah.
Mhm.
Let's hear about it because I want to know if she would be a good fit to be that guardian.
I started smiling because I'm going to put in who should never see my son. Make sure I'm going to add that too.
You see, I
It's important. Yeah, it's
mean,
important.
you
We
know,
we
it
add
is.
disinheritance language to our estate plans all the time.
Yeah, people
And
get
so
disinherited all the time, and it's important, if not with just disinheritance, but if you don't want that person to
serve.
play any fiduciary capacity, trustee, executive, personal representative, guardian, power of attorney, healthcare surrogate,
You have to say it and name it.
you should specifically
Right.
exclude them out of those roles in your
I
document.
know a lot of people wish they just had this information. So I want to take a break for a moment to just thank you for your mission to educate people. And so when you initially did your introduction, you said Florida, then you said New York, where
Mhm.
our viewers are from all around the world.
Good.
And so you're going to be educating people around the world. And of course, we understand that different states have different rules, etc. But at least they can start having those vital conversations because we're just thinking about, oh, we'll avoid probate, get a trust. No, we need additional language put into the
Mhm.
trust. And so, can you tell me a real life application to where having these documents written actually prevented a family conflict?
Um, I don't know if it was a family conflict, but I do have sort of a nice heartwarming story that I can tell. When I first started practicing here in Florida, I wanted to start this whole legacy idea, and I was recording clients and doing legacy interviews, which is an option with some attorneys as well. We did legacy interviews, like what do you, so there was this lady who was an absolute sweetheart, Cuban lady, and she had three daughters who were sort of like, I guess, vinegar and oil because they were just is it vinegar and oil and water?
Hey, they just did not mesh too well, right?
Complete, it's always crazy when you see, people who are raised in the same exact household but are completely different. And that
Mhm.
was the situation with them. And she always joked with me. She was like, I had to keep them coming to the holidays, otherwise they never get together. And they always ask me for, my recipes. And I tell them, no, I'm not giving them to you because I'm the only one that has them, and I want them to make sure they still come home for the
I
holidays.
love that.
So, as you can imagine, I loved it too. And my first thought was, we have to get this. And so we recorded an interview, a legacy interview with her. And in the interview, she gave all of her recipes to the three girls. And the way those women broke down in my office was just, for the first time, I saw them all actually liking each other.
Yeah.
And they all had that common, and it was something beautiful that, their mom was able to do at the end. So that is, as sort of heartwarming as it could be when it comes to real conflict.
Mhm.
Yeah.
I've
Siblings.
literally written a book on it.
I mean, yeah, which is coming out soon, so we're super excited about that. But yeah, I
Congratulations.
think that's
Attorney Ruby, you were so wonderful during our consultation. So I want to thank you. And you gave me some valuable advice on how to protect my business and also protect my property. What
Mhm.
information do you have for our viewers?
Um, That's a loaded question, but
Hmm.
when it comes to businesses, we want to make sure that we have the proper documentation. So here in Florida and in a lot of states, it costs a couple of $100 to set up an LLC. Great first step. As a business owner, you set up your LLC, you got your EIN, and now you are in business. And you think that by registering yourself on that website, right? Every state has a website where you can set up an LLC yourself. You think by putting your name into that website, that you automatically are the registered owner of that LLC. When in actuality, what your Department of State reflects on their website is different, is not really, doesn't really control the business itself. Everyone who has an LLC must have what's known as an operating agreement. And this operating agreement is seldomly prepared by business owners. Even when your CPA prepares the LLC, they cannot by law prepare an operating agreement. Hopefully they'll tell you, hey, you should speak with an attorney, or if they set it up themselves. We have a beautiful do-it-yourself system here in Florida where it costs $125, and just like that, you are a business owner. And now the operating, what's on SunBiz in our state, is not indicative of who owns that actual LLC. So if you have a business and it is an LLC, you want to make sure you have an operating agreement. That agreement is going to control the operation. Through that agreement, you can include a provision that says who's going to be the beneficiary of your interest. You can also say in that operating agreement that you assign your interest into the trust once you have one.
Wow, that's powerful.
So you own that LLC, you managing it, but when you die, the trustee is going to be the one that steps in your shoes as the member of that LLC.
Well, I want to tell you this, that someone actually went into SunBiz. Of course, I wrote the governor. It shouldn't be that easy. And they changed the ownership of my business. And then when I start doing the research, I'm now, who is this person? It was somebody in California, but it was happening to lots of business owners. They just didn't make it public. And so knowing now that this operating agreement is so vital, I have one, but my business has been open for 17 years. Where is that? Who knows? So yes, you've given me homework, and I applaud you, because not too many people can give me homework.
You usually give other people.
Yes.
Yeah, I mean, having that document, when you pass away, if you have a signer, that's not enough. Like, you might have your husband as a signer on your bank account, on the business bank account. But once you pass away as a member, that account is going to be frozen. If you have people on payroll, if you have things that need to still get paid, now that your source of income for your kids and your family is completely frozen because you didn't prepare that operating agreement. If you have a corporation, something that ends with a corp, C-O-R-P, or if your business ends with an Inc., I-N-C, that is a corporation. You have a C corp. You need bylaws. Okay. Operating agreements, LLCs, bylaws are for corporations. People will often say, I have an S corp. Great. That's a tax election. Not the entity type. You either have you can have a partnership, other things, but an S corp is just a tax election. As an LLC or as a corporation, you can elect S corp status. But those are going to be the operating agreements. And then you also want to have what Karen and I have, which is a partnership agreement. If you have a partner. So if you have a partner, it's important to lay out the expectations between the two of you. Again, if you don't feel comfortable laying these things out, you have no business being in business with them.
You want to, we're going to discuss how we're going to start it, but in case it doesn't work out, we want to have that succession plan. We also want to talk about how it's going to end.
Yeah, because at the end of the day, Karen agreed to be in business with me, not with my son and my daughter, or not with my partner. So what happens if one of us passes away, if I pass away, I have a business, but she doesn't have the liquidity to buy my family out of my book of business. So those are all things that you need to, business attorney is going to help you set up those contracts, but an estate planning attorney is going to help you create the plan of what happens again in divorce, disability, or death. And those are the three things as a business owner that your operating and your partnership agreement should cover.
Mm. Now, if you don't want to speak on this, it is okay.
Okay.
Content creators are the fastest growing industry. So we're
Mhm.
going to talk about properties in a few moments. What advice do you have for content creators?
So for content creators, I always say that you should, first things first, do you have your LLC in place? Your channel and your royalties or whatever you're getting should be payable to an LLC for various reasons. Aside from limiting your liability, it's also going to give sort of an ability for the business to keep on going after you pass away. Because once you pass away, those YouTube channels, those at Facebook's, they have really strict privacy laws that will shut your channel down. And
Yes.
you don't want that. So an LLC doesn't die so long as you have your operating agreement. An LLC doesn't die, so you never have that fear. So everything should be set up in the name of that LLC. And then that LLC, will manage it. You always want to have, from a business perspective, and this is business planning, but you want to have that person who is either going to take over, potentially purchase your channel from your family, or going to be the liaison or the person that your family goes to for help in continuing to run that business.
Thank you.
And,
That's great advice.
think about a monetary buyout. We work with a lot of financial advisors, not just because they refer business to us, but we literally work with them on their estate plan. And they have unique needs just like that. So what happens to their book of business when they pass away?
I think it was T-Pain and The Weeknd. They
Mhm.
recently sold their catalogs for millions of dollars. So if anybody wants to purchase my catalogs, my catalog, you don't have to wait until I'm no longer here. We can go ahead and have this conversation now.
Mhm.
So
Mhm.
now, whenever someone has a property, how does having an attorney who helps with estate planning, how does that help to protect the properties, whether it's commercial or residential property?
So the way it's handled and protected depends on how we're characterizing it. So your homestead typically either gets transferred into the revocable trust, or if you are in a state that has ladybird deeds, we'll discuss that at some point, I'm sure, you will designate the trust as the beneficiary. So your homestead, again, I guess it just depends on where you are in the world, not just the state, but or the country. In the state of Florida, for example, we have what's known as homestead protection. So it is protected against creditor claims.
Okay.
You typically do not put or cannot put your residential property into an LLC. Now, if it's an investment property, you want to set up a different LLC structure. Now, that plan is going to be different if you have one rental property versus a vacation property, real estate empire. Because if you have multiple properties and you are a real estate investor if you're a flipper, we're going to do one thing. If you are a long-term holder of real estate, we're going to do something different. If you're wholesaling is going to, so it depends on how you're investing in real estate.
And that's
It's
the
going
importance of
to,
those consultations
oh
that a
yeah.
business owner is going to have with you at the Heiress Law Firm. And I do want to say this, that while Attorney Skyers and Attorney Montes, while they are attorneys, they're not your attorneys. So,
Thank you.
so we're going to throw those disclaimers out there. Okay. So
Yeah,
don't be
this is
like,
just
hey,
Yes, this is
this is
just
for educational
educational.
purposes.
This is just educational purposes, but we do invite you to schedule a complimentary consultation with either myself or with Ruby, preferably with Ruby, so that I can play outside and go grab some more folks to talk to. And that's kind of how we're structured. We're structured to sit down with you for 30 minutes. We'll give you a complimentary consultation. Then we'll give you a recommendation on what we think is best for your family based on what you told us. So again, reach us on HeiressLaw.com or reach us at 877-44-WILLS.
Yeah, and so before we go into the full plan, what if someone's saying, "Oh, I can't afford an attorney"? My thought is like for me, an accountant, a CPA, not someone who just not the tax lady. Having a
Uh-huh.
CPA has been so vital for my business, for my finances. I'm not afraid to open letters from the IRS, and if I am afraid, I'm like, "Here, open this letter for me," because we have that I have someone who can provide me with the knowledge, and someone who can hold me accountable.
Mhm.
So, for someone who says they cannot afford to have an attorney to help with their estate planning, what would your response be?
You want to do
Oh,
it? I was gonna say you can't afford to not have one, but
yeah. Well, I think this is how we really look at it, right? We try to, do numbers. And so here statutorily, which means based on state law, if you do not have a plan, the state of Florida, the state of New York, the state where you live, reside, and die has a plan for you. And it may not
Mm,
necessarily be the plan that you want.
that's
Right?
scary.
Oh, absolutely. And think about it. We just gave you a whole number of an average home in Florida. If it's $400,000, if your family has to probate that home, 3% of that is $12,000 before your family gets to go to have their property back into their name. And so if you just think about it in those numbers, we get 3% of the total value of your estate. And think about those numbers as opposed to what you're putting out up front.
So,
Wow.
and I know the question everyone always wants to know is how much is it all going to cost? How much is it all going to cost? So we like to do, we are transparent in our pricing. This is going that the cost of an estate plan, a comprehensive estate plan, not just a will, not just a fill in the blank sort of trust. A comprehensive estate plan is going to vary significantly from one coast to another, one city to another, and also in what you are trying to protect and create. So, if we have someone who has a taxable estate, which is anyone over the $15 million mark, that estate plan is going to be a lot different than someone who has modest assets and income, or even, but for the most part, when you have a comprehensive estate trust plan, you are going to look to spend anywhere between $2,000, $2,500 up to $4,500, 5,000 is sort of the range,
That
depending
is
on
so
if it's a
reasonable to
single
protect.
person or a couple. When you think of it from that perspective, and you think of it from the perspective of what Karen mentioned, it is so much less expensive to do it's almost like you're prepaying the probate, right?
Yes.
You're handling it ahead of time so they don't have to pay it times three, times four, what you
Mhm.
paid. So when you think of an estate plan, yeah, think of it. It is going to be a couple of $1,000s. But think about how much the heartache and the financial stress that you are relieving from your children, especially if you have minor kids
You
Yes.
who
avoid,
are dependent
yeah,
on
you
you.
want to avoid court and conflict. That's pretty much
We got paid a lot of money to go to court and be
And
involved
then
in conflict,
and then the
you know.
infighting, between the
Oh
siblings. We
yeah,
can avoid all of that.
everything's right. Oh
Yeah.
yeah, yeah.
And so documenting wishes without a full plan. So Karen, what is a full plan and what happens if we fail to plan?
Well, the full plan was exactly what Ruby said. An entire estate plan is going to cover a revocable trust, revocable trust, as you ladies like to say, a revocable trust. You're going to have a living will. You're going to have the advanced health care directives, the power of attorney. It's a comprehensive plan. We're going to sit down. We're going to talk to you. You may come from you may have a new blended family and want to care for stepchildren or a new spouse. You may want to care for, your biological children and not for your new, it just so many things that you can do. But designations, at the bank, you can name POD, payable on death. Some states call it transfer on death. On life insurance policies, as long as it's not a child under the age of 18, you can name someone, right? The name of the game is to have all of your assets go somewhere, preferably a revocable trust, so that you can avoid probate.
Yeah. So if you can't have a full legal plan, Eunice, what you want to do is beneficiary designations on all of your accounts and all of your assets. But you can only designate beneficiaries who are over the age of 18.
Right. Which does, and what happens a lot, we see this a lot, is people name their children automatically right now for, and then what happens, heaven forbid something happens to them before the age of 18, that child still needs to get a guardian. Guardianship is very expensive if you have not already pre-selected one. And even still, in order to get that money, that child, it still has to go through court. So imagine you have $1 million policy and your child gets it at 18 if you don't get it into a trust. So 18 years old, $1 million just doesn't work.
Yeah, so you could document your wishes via those beneficiary designations, but it's only recommended if you are naming adult beneficiaries who are not concerned with them receiving the money outright. And for some people, that is a good option. So just so that we're clear, we don't recommend a trust for everyone, right? Everyone doesn't need a trust. Some people do. I do. I have a minor child. I need a trust. There is no way around it. You have a child with special needs, you need a trust. You have a child, who is going through a divorce, you need a trust. So you need, in certain circumstances, everyone needs an estate plan. Okay, everyone needs an estate plan that's geared and centered around avoiding probate. So if you are a client in your 80s and your children are in their 60s and you're leaving everything to them and you have a house and 2 bank accounts, $40,000 in savings and you just want to give it to your 60-year-old son directly, beneficiary designations work perfect. But that's the plan. So that's your estate plan, because clients who do a will-based plan without a trust, a plan without a trust is just a will-based plan, then that gets coupled with beneficiary designations. And that's where the POD, TOD, payable on death, transfer on death, ITF, in trust for, you can do that on your checking account. You can do that on your savings account. You can do that on retirement accounts. You can do that on life insurance. And in some states, like Florida, you can do that with real estate as well, with real properties. So we have this magical deed. We call it a ladybird deed. It's technically an enhanced life estate deed. And what it basically allows you to do is designate a beneficiary for real estate, for your real properties, any real estate you might have investments in. So that works really well, again, if you have a child who's an adult. Responsible. If you have 5 children, I'm not going to recommend you do a ladybird deed, because you're going to put ownership in 5 children, 5 adults.
No.
Okay.
That's going to be so complicated.
Who are going to have different philosophy. One wants to invest in an Airbnb. One wants to sell it. One wants to fix it. One wants to live in it. One wants to conserve it because it's a family house.
And then we're going to court.
And now we're in court. You have too many steps.
And then no one paid the taxes. Everyone's fighting. No one paid the taxes.
And then you lose it. And then you lose it. Yeah. So that happens entirely too often.
In our past episode, we talked about, things that people forget to do or what not to do. And so I do want to bring this up, that now that you have all of your documents and you have everything executed, I know someone who ended up divorcing their spouse, but they never changed their beneficiary. So the spouse that they didn't expect to get anything ended up getting most everything. So how could someone prevent that from happening?
So the state of Florida, state of New York, and most states have now incorporated a law which does sever spouse's benefits under a will that was done during the marriage. So the divorce would sever those rights, at least in the state of Florida and as well as the state of New York. So there's a law that says if you get divorced and you name them in your will, they're going to be excluded. Okay. Same thing if you name them as power of attorney and if you name them as healthcare surrogate, the law says that those are now void. They no longer can be a power of attorney. However,
yes.
Yes. How is the bank going to know you guys got divorced? How is the hospital going to know that you guys got divorced?
How is the insurance carrier?
How is the insurance company going to know? So now it's a test to see it's a race to see who gets to the life insurance first. who gets to fill out that form first. And if he fills it out first before your kids, now the money's going to go directly to them. Now they have the option. Now your kids are going to sue him, right? Going to sue their ex-stepfather to get this money back. Well, guess what? If the money is spent, yeah, you can sue me all you want.
Or if they're a minor.
Or if they're a minor.
Yes.
Or if they even know about it.
No, that's a...
So regardless of what the law says, it is so vital and important that if you do get divorced, that you do update your estate planning document. And more important, if you are separated but not divorced, right? Do you want your soon-to-be ex-husband to make medical decisions?
Take some notes here. Whoa, this is a lot.
Do you want them to make those medical decisions for you while you're going through a divorce?
And we see that so much. We see that all the time. And we actually had a lot of situations where people don't update their documents. So that is why, when you ask the question of like, what do we say to folks? We go, do your homework. These are important things. So after execution, yes, follow our instructions and fund all of your things.
Yeah. So one thing that while we're on the topic of separation versus divorce, some states do not legally recognize separations. Okay. So you could be legally separated from your husband for 20 years and have had no commitment, but you're still legally married because you're getting benefits, or you're doing, whatever, or you never wanted to change your name, or who cares, whatever. Whatever.
You didn't want to pay for the divorce.
Whatever excuse.
I know, that's usually it. Yeah.
Okay. Let's say if you die, your separated husband still has legal rights to your estate. Okay. So they're going to either get 50% or the entire estate. Now, let's say you were smart enough and you said, no. I am going to do a will. I listened to Ruby and Karen, and I'm going to do a trust too. I'm going to avoid probate. I'm going to update my power of attorney, name my kids, blah, blah, blah. Everything's good. Everything. If you die married, they are still entitled to what's known as their elective share.
And they can still make the funeral arrangements for you. I've heard that happen before also.
And take the action to be
spiteful, right? And so, yeah.
just being spiteful. No, I'm the husband. No, sir, you've been gone for 20 years. So
for situations like that, I know that it may sound attractive to remain married for whatever reason, but you want to think about those things. And again, that's why you go to an attorney who's competent enough to sort of go through all of these what if situations, and let's get down and dirty. And the same thing with, people who carry themselves out to be husband and wives, but are not.
Yes,
that's the opposite of, we have
a lot, because I'll tell you that in the Hispanic culture, right? Mi esposo, mi esposa, my husband, my wife, but there's really your boyfriend, right? Or your family just recognizes tu marido, right? So your family recognizes your, non-spouse, right? As your husband, just because that's the term. And so we have to be very careful when we talk about, how long have you been with your wife? Are you legally married?
And that's the first question.
And so that's the first question we have to ask, because some people think that even if they're legally separated or they're separated in Florida, that it's legal, and Florida doesn't recognize that.
So it's same thing. So the problem we've had situations where partners have taken title to property as husband and wife, and it says, John Smith and Jane Smith as husband and wife, and they're not married. And they're legally
Is that common law?
No, it's a good question. That's what I was going to bring, because this is especially with the older generation, in common law marriage. I don't think there are any states in the country that recognize common law marriage anymore.
Wow.
So common law marriage does not exist in the state of Florida, does not exist in the state of New York. After
it's not been recognized.
Yeah, it hasn't been recognized in a very long time. So common law marriage is not a thing. So if you take title to a property as husband and wife, typically if you are married, that's known as tenants by the rights of entirety. Okay, so it automatically passes to the survivor when one of you dies. And that's how automatically, when people take it as husband and wife, that's automatically what happens. Enter a death of the family, one of the owners, and now the kids or whoever fills out that death certificate. And in the death certificate, it says marital status, and they put single because they are single, they're not married. Now, when you go to sell this property, the husband who's still alive is not going to be able to sell the property because that 50% belongs to his partner and not him. And it automatically transfers into what's known as tenants in common.
Wow.
Tenants in common means that when one owner dies, that 50% goes down to their heirs or their estate. So now the 50% that belongs to wife goes down to her kids, not automatically to the partner of 30, 40, 50 years.
Look, I'm going to be scheduling so many consultations and meetings with you all because it's a lot. So I'm thinking about protecting my son, but I'm also, dating. It's a lot to protect.
Oh, yeah.
And so,
Welcome to the modern world. Yeah.
yeah, it's a lot to adult right now. You have given us such valuable, information. I want you to challenge our viewers. Give them something, a takeaway. What do you want to see from them? We won't say necessarily this week because of the holiday, but what you expect from them, something that they can do in January to help improve their financial, their legacy planning.
Oh, I think mine will be for you to encourage one person in your family to have this conversation, whether it be yourself having it with someone else or asking your other person, whether it be your parents, your spouse, your boyfriend, whoever it is that you love and care for, to say, hey, listen, what do you want to happen to you in the event of death or incapacitation? Who do you want to speak for you? Who do you want to talk to the doctors? Do you want to be buried? Do you want to be cremated?
I want to play devil's advocate. I'm going to be that spouse. Are you trying to kill me? Do you think I'm going to die?
No, not at all.
No, not at all. And then I'll go usually into, well, let me tell you what happens if you pass away without a plan, right? And then I say the state of Florida's plan or the state in which you die, that plan may not be the plan that you want, right? So I inherited from my father's ex-wife. I'm sure she never wanted me to inherit. I'm of a new marriage, an intact marriage, but unfortunately there was no planning in place. And so that's another story. However, the point is, when you get that pushback, you say, we try to control everything. We plan everything, right? So let's plan for death. Let's plan for incapacitation. And let's let our families know what we want to happen at that unfortunate time.
Wonderful, wonderful. It's a great takeaway. What challenge do you have, Attorney Ruby?
I'm going to challenge you. If anyone listening is a business owner, entrepreneur, have a side hustle, whatever you have going, content creator.
Everybody's a boss.
I want you to have a meeting with yourself. So I'm talking to the soul entrepreneurs who stay up at night to midnight. I know the hustle. I feel your pain. I've been there. So I want you to sit down and have a meeting with yourself. It's stupid. It sounds crazy to have a meeting with yourself, but I want you to set down goals for 2026. That's my challenge to the business owner. Set down those goals for 2026 and make sure that right somewhere on the top of that list is make sure your books are in order.
I love that. And we're not just talking about, because usually whenever a business owner makes plans, it's plans for, increase, how to get new clients. We're talking about the operational agreements. We're talking about, having those designations in place. So, for their plan, because they've never heard this before, Attorney Ruby, what should be like 5 key actions that they should, I put up 4 fingers, sorry, 5.
five key actions that every business owner should have is, again, a plan for what happens if you want to scale your business. So what is that going to look like? And do you have the procedures, systems, and operations in place? And that's only going to happen if you have that starting baseline, which is the operating agreement and the partnership agreement. So I guess number one should be legal documentation to regarding the operation of your business. That legal document is going to have what happens to your business if you become disabled. Is it going to keep on going, or is it going to sort of stop with you? What happens if you die in the business, and what happens if there's a death, if you die, if there is a death in your business of you or one of your key members, and what happens if someone gets divorced in your business. And that's important because you don't want your partner's ex-wife to have a stake in your business,
which happens all the time.
Okay. So you want to have that succession plan in place for all three of those contingencies. You want to make sure to have a clear financial segregation of assets, so you don't want to commingle personal assets with business assets. As an attorney, if I'm suing a business owner, I'm going to try to do what's known as pierce that corporate veil. That corporate veil of protection, I'm going to pierce it by showing the judge that you are not a real business. That this is just your little side hustle and you're not really operating on business levels. So if you want to be a business, you want to operate on that level and you want to have that protection. Okay. And then the last thing, insurance.
Look, I have to go. I'm going to watch this about 3 times. Okay.
I don't know if I mentioned 5 or 4 or 6.
It's okay.
It's a big one. Insurance, I'm not an insurance agent. I don't sell life insurance. I don't sell business insurance. No type of insurance. I have 0 stake in the game. But I do encourage life insurance for yourself, for your children, for different aspects of your life. And if you are in business, regardless of what type of business, you have your homeowner's insurance, you have your liability insurance. We live in such a litigious world, and I hate when I see small businesses destroyed because of a $2,000 yearly insurance bill they didn't want to pay.
And I went a step further. Like I thinking like I wanted to actually have the insurance in place in September, but of course with underwriting and everything else, it wasn't approved until October. But I have insurance where if I get injured, if I hurt my leg, it is going to pay for someone else to come in and take my place. So it's kind of like, we think about death and dying, but what happens if you're injured? I still need my business to continue because I need to make sure that my staff, they're still taken care of, and they can't necessarily do what I do, but at least I can hire somebody to go in and be the CEO. So definitely that was some wonderful advice. Look, ladies, I am full. I am full. I have homework. Do you have any final words to share with our audience?
It's not meant to overwhelm anyone. I know we're giving you a lot of information, but we do a lot of hand holding. Estate planning is a different type of relationship than your divorce attorney, than your criminal law attorney, than your tax attorney. We have a different relationship with our clients, and we like to say that we grow with you. So unless, I marry a billionaire at some point in my life, I'm going to be in business for a long time. And we want to create those lifelong relationships with all of our clients so that we can change your plan as your life changes. And we're going to walk you through every step of the way. So you're not, sort of going to be lost in this whole mess of it sounds like, it sounds daunting, but it's not when we take it one step at a time. And the first step is just to schedule that consultation. So pretty simple.
Perfect. What about you, Attorney Karen?
Yeah, so my takeaway is going to be, first, thank you so much, Nurse Eunice, for having us. This is always a great time. We love educating the community. But my call to action is, please, talk to your family, have that conversation with yourself. What is your legacy? What do you want to leave behind? Right. Mm-hmm. And then schedule something with us. It's going to be a complimentary consultation. You can find us on social media via our name. You can find us with HeiressLaw. And again, one of the major things that we have to remember is, we say life is short, right? So during this short time, make it happy, as happy as you can, right? But be responsible. And I think being responsible is handling your affairs post death, right? And what you want to happen, not only to your property, but to yourself. And I think that's my takeaway, my leave behind. I wish everyone an amazing new year. It's always great to be with you here, especially with my amazing partner. We've just hit our 1 year anniversary together. So thank you.
Congratulations.
So thankful for her, for everything she does. I know that you can feel her energy, and I get this from her every day. So if I'm sitting here, I'm like, yeah, that Ruby say everything, because she's just an amazing partner. And so, like she said, we've taken care of our paperwork. We're the first generation in our family to not only be attorneys, but the first to have estate plans. And we hope that you will join us in this mission.
Yes. And so my takeaway is I want to thank you too. I want to thank you all for your mission to educate people, not just in New York, not just in Florida, around the world in multiple languages. And I also want to thank you all for, the consultation, the family consultation that you did with me and my family. 30 of us on a Zoom, 30 minutes. You got us all scheduled in for our
an hour.
I'm sorry.
We're not that good. You got
30. We were special. All right. So, and then you got us all scheduled in for our individual consultations. When I say individual, for me, I'm single, so it was individual, but I'm sure you met with husbands and wives, and you helped me to create my plan. I've been uploading my documents, and I want to encourage someone else who doesn't know where to start, but you do know that you want to avoid probate. You do know that you don't want the government taxing your heirs. You want to try to avoid that. I want you to My call to action to you is that you actually reach out to the HeiressLaw firm. The link will be in the description, and that way you can schedule your consultation to figure out, what questions you have, how they can lead you. And it's not that expensive. We're talking 2,500, excuse me, to 4,500. No, not thousands, 2,500. You all spend more than that on your vacations. So I think it's well worth it. We cannot afford to not have these vital conversations. And so I look forward to seeing you all in the next video. I want to make sure that you like this video, leave your comments. Attorneys Karen and also Ruby will be monitoring the comments. But if you want to bypass comments, go straight to their website and schedule your consultation. And we'll see you all in the next video. All right, everybody. Happy New Year.
Bye.
Bye.